There are other things Congress can do under its Section 5 power to protect the 14th Amendment and Section 2 power under the 15th Amendment. Let me go back to the no state shall language of those two clauses, Section 1, the second sentence of Section 1 and Section 1 of the 15th Amendment. Obviously Congress can regulate state action under these, but it can actually also regulate some private action under these as well. How is that possible? I'll explain. The people who wrote the Reconstruction Amendments, many of them were anti-slavery and some of them were abolitionists. And what really stuck in their craw was a decision by the Supreme Court in 1842 called Prigg versus Pennsylvania. This was a decision in which the Supreme Court said Congress had the power to pass the Fugitive Slave Act of 1793. The Fugitive Slave Act is an enforcement of the Fugitive Slave Clause in Article 4. What Justice Story says in Prigg is that it's true that the Fugitive Slave Clause is directed towards states and requires states to return fugitive slaves. Nevertheless, says Justice Story, Congress has the power to enforce it to prevent private interference with the rights of slaveholders to get their slaves back. And guess what the framers of the Reconstruction Amendment did? They were very clever. They said, okay, two can play at this game. We are going to give Congress the power to do for the freedmen exactly what the Supreme Court gave Congress the power to do for slaveholders. And they wrote the Reconstruction Amendments with the Fugitive Slave Act in mind. And in fact, some of the early Reconstruction statutes are written modeled on provisions in the Fugitive Slave Act. That would suggest that Congress has the power to prevent private interference with constitutionally protected rights. This idea was, in fact, a really important source of civil rights legislation, and Congress used that idea in the 1870 and 1871 Enforcement Acts. The Supreme Court then, of course, snuffs it out in a case called Cruikshank, in which it basically got rid of the indictments, criminal indictments in the Colfax Massacre. But the Supreme Court was incorrect. That's certainly not the way in which the statutes were written, and it was certainly not the way in which the 14th Amendment and 15th Amendment were written. There's one other thing I should also point out about the Congress's ability to protect private citizens through legislation. Now, many of you have been told, and you probably believe, that the paradigm case of what the 14th Amendment is designed to prohibit is the Black Codes. These are laws that tried to reduce blacks to the same status as slavery as they had before the 13th Amendment. Well, that's correct, but it's actually incomplete. There are really two paradigmatic cases that give rise to the 14th Amendment. The first is the Black Codes. The second is the conditions in the South immediately after the Civil War in which Southern whites terrorized, and I use the word terrorized advisedly, terrorized blacks and white unionists who supported the rights of blacks. And what happened was states in the South just didn't pay any attention. They turned a blind eye to it. Now, if you go back and read the report of the Joint Committee on Reconstruction, you'll actually discover there's more discussion of this problem, the failure of states to give equal protection of the law to citizens, than there is actually on the Black Codes. It is impossible that this was not an important purpose behind the creation of Section 5 of the 14th Amendment. And we see it in the Civil Rights Act of 1866, repassed in 1870, and in the 1871 Enforcement Act. The basic idea is this: Congress has the power to protect people from state neglect of law. If states are not protecting their citizens, some class of citizens, or citizens who exercise certain rights, through the tort law or the criminal law, Congress has the power to pass such legislation. And that's exactly what the same Congress did in 1870 and 1871. You may say, but wait a second. I thought, in cases like United States versus Harris and United States versus Morrison, that wasn't okay. It wasn't okay because you can't have a nationwide statute that bans private violence, right, if not all states, in fact, are not equal in terms of how they protect or don't protect their citizens. But you know what? That isn't correct. And you know why? The 1866 Civil Rights Act applies nationwide. It doesn't apply only to states where the rights of blacks aren't being protected. And not only that, the 1793 and the 1850 Fugitive Slave Acts, they apply not only in Massachusetts and Pennsylvania, where people are anti-slavery, they also apply in the places where slavery is protected. The idea that you can't have nationwide statutes designed to protect against violence against particular groups is a canard which occurs after Reconstruction. In fact, if we understand the purpose behind the Reconstruction Amendments and the text of the Reconstruction Amendments, we'll see that Congress is fully able to pass all modern civil rights legislation. Such legislation will be passed by a representative majority of American citizens. It will have democratic authority behind it and will be enforcing the values of the Constitution. That is the way in which the 14th Amendment guarantees equality and justice for all. Thank you very much.